Good afternoon, everyone, and welcome. Thank you for joining us today. I am Brad Phillips, a partner here at Wagner Sidlowski. And if you've seen any of the promos for today's subtopic, being part 2 of the Notice of Objection, Theory and Strategy, you may have seen that I was going to be presenting the seminar along with my partner, Peter Neufeld. However, Peter had to be in court today, so graciously pinch hitting for him is my colleague, David Friedman, who is also the co-chair for this Lunch and Learn series on will challenges. A brief blog post has been prepared in advance of today's seminar on this topic, and a link to that blog can be found in the Zoom chat. Just by way of brief introduction, in addition to being co-chair for these sessions, David Friedman is a professor in the Faculty of Law at Queen's University and counsel at Wagner Sidlowski. David teaches and writes in the areas of wills and estates, trusts, and guardianship law. I am Brad Phillips, as I said earlier. I'm a senior partner here at the firm. I've been a litigator throughout my career with a diverse practice history. Today, my practice includes estate and commercial litigation, including doing professional negligence, defense, and coverage work for LawPro in both estate and non-estate matters. Before we get started, we just have a few housekeeping notes. We would ask that you please leave your microphones muted at all times unless you are asking questions at the end of the presentation, after which we would ask that you mute yourself again. And as you are all should be aware, this seminar is being recorded. In terms of a certificate of attendance, it's actually going to be uploaded to the chat. So please download it from the chat for your records, because we aren't going to be sending any direct emails to the participants. And last, but certainly not least, we want to send a big thank you to all of our sponsors, B'nai B'rith of Canada, Concentra Trust, Scotia Wealth Management, Torque and Mains, TD, and BMO Trusts and Estates. This event is complimentary because of them. And if you enjoyed our seminar, we ask that you consider making a donation to the B'nai B'rith Canada Food Program if you haven't already. Elite Mannheim is here today with us today from B'nai B'rith of Canada to tell us a little bit about the organization and its charitable work. So I will hand over the floor to Elite, and please take it away.
Okay, so good afternoon. As you mentioned, my name is Elite Aronson Mannheim, and I'm an associate in the Legal Affairs Department at B'nai B'rith Canada. I've been asked by our CEO, Mr. Michael Austin, to greet you today and speak a little bit about our annual audit of anti-Semitic incidents. Since 1982, B'nai B'rith Canada advocacy arm, known as the League for Human Rights, produces an audit each year. The audit reflects the level of anti-Semitic incidents reported to and monitored by the League. These statistics include information gathered through B'nai B'rith anti-hate app, anti-hate hotline, report and incident webpage, as well as collected from police and law enforcement agencies. The audit is cited regularly by Canadians and international mainstream media outlets, public officials, NGOs, and government bodies. The audit focuses on anti-Semitic incidents that both meet and fall short of the criminal code definition of hate crime. This is essential for capturing the climate of anti-Semitism in Canada, which requires independent tracking and assessment. As such, the audit serves as a barometer for anti-Semitism as a phenomenon in Canada. The 2022 audit that we have just released recorded 2,769 incidents, the 5th consecutive year in which the 2,000 plateau was exceeded. There are almost 8 anti-Semitic incidents happening each day in Canada. Harassment constitutes nearly 85% of the in-person incident. There were 2,056 incidents of online anti-Semitism, representing 74.3% of the total incident for the year. A 64.8% jump in incident in Ontario alone as compared to 2021. The numbers do offer some welcome news. Documentable violent incident targeted at Jews decreased from 75 in 2021 to 25 in 2022. A variety of factors likely contributed to this decline after the 2021 Israel-Hamas conflict that led to a record number of attacks on Jews in Canada. Relative peace in the region in 2022 resulted in far less violence. My 2 minutes are up, so I'd like to thank you all for your contribution. It will really go a long way.
Thank you, Elite. And so, without further ado, let's get started. To begin, and for the benefit of those who were not here for part one of our lunch seminar talking about the notice of objection, I propose to do a brief recap of some of the issues that were covered during the first seminar while we explore some other issues that weren't touched upon in detail. So the first step to challenging a will in Ontario depends on whether probate has been granted. If probate, or as it is officially defined by the courts, a certificate of appointment has not yet been issued, then a person objecting to the will can file the form called a notice of objection with the local registrar. So let's assume for the moment that a certificate of appointment has not yet been issued by the court, and therefore the filing of a notice of objection is a viable option. The first question that arises is, can any person who wants to object to a will do so? And for that, we first turn to Rule 75.03 sub 1 of the Rules of Civil Procedure, which states that at any time before a certificate of appointment of a state trustee has been issued, i.e. before the court grants probate, any person who appears to have a financial interest in the estate may file a notice of objection with the court. Similarly, Section 23 of the Estates Act notes that all persons having or pretending to have an interest in the property affected by the will may be permitted to become parties to a will challenge. As was covered in greater detail in part one of our Lunch and Learn seminar, the term financial interest is not defined in the rules, but has generally been interpreted quite broadly by the courts. As noted by the Divisional Court in Smith and Vance, with respect to both Rule 75.03 sub 1 and Section 23 of the Estates Act, where the stated interest of an objector is clear and obvious, for example, the claimant is a named beneficiary, there should be no difficulty recognizing the status of that person as a party. Different considerations apply where the claimant is one who pretends to have an interest. The word pretended is not to be interpreted as claiming or professing falsely or deceptively, but rather as alleging or laying claim to an interest in law. One who pretends to have an interest is not required to prove that he or she has a financial interest before being permitted to become a party under Section 23 of the Estates Act. If such were the case, the inclusion within Section 23 of entitlement of those persons pretending to have an interest would be redundant and superfluous. However, claimants must do more than simply assert an interest. They must present sufficient evidence of genuine interest and meet a threshold to justify inclusion as a party. It need not be conclusive evidence at that stage, but must be evidence capable of supporting an inference that the claim is one that should be heard. And it's also important to note that the objector does not need to prove a financial interest in the estate at the time of the objection to meet this threshold test. If an objector might have a financial interest in the future, in the event that the court makes a certain findings in the objector's favor, that is sufficient to meet this test. So for example, if your client will be seeking to strike out the current will and would inherit under a prior will or on an intestacy, that would be sufficient to establish a financial interest in the estate. But again, as was reviewed in greater detail during our first Lunch and Learn session on this topic, there are limits to who meets this definition, and the courts will strike out a notice of objection if it is not satisfied that a person has proper standing to do so. But for today's purposes, let's assume that the objector meets the required criteria. Typically, lawyers use the notice of objection as a pro forma document that is prepared and filed quickly because it is supposed to be the first step in pursuing an application for actual substantive relief and to ensure that the estate trustee can't take any steps to administer the estate without notice to them. So it generally contains very simple statements like the objector objects to probate being granted because they don't believe that the testator had capacity at the time the will was executed, or that the testator was subject to undue influence, without any significant detail. But I would like to bring in David at this point to discuss his views on this typical approach to preparing a notice of objection.
Thanks very much, Brad. Let me just say thank you very much to my colleagues for inviting me to participate in this seminar today. So this question of how to structure a notice of objection is kind of interesting because to a certain extent, it reflects historical practice and it reflects what the legal culture is at a given time. So we all know that the law in this area is old and the procedures in this area are old. And that's important for lots of reasons, mainly for predictability and to allow for approximation of laws from one jurisdiction to another so that grants of probate can be resealed. But things do kind of, change over time. So one of the questions that I think is important to consider is really what do we want from a notice of objection? Like, how do we conceive of it legally? Is it just a notice to the registrar, or is it essentially a pleading? That is the commencement of a legal proceeding. Traditionally, it's only functioned as a notation to the registrar. But you have to realize that that practice arose in circumstances where, for example, the surviving family members, as a right, could have the will proved in solemn form, that is by evidence, regardless of whether there was an allegation that the will was defective or invalid, in some way. And I would suggest that in the last number of years, what we see is that our courts are paying greater attention to estate litigation and really pursuing a policy of trying to stop spurious will challenges as early as possible. And we know that the cost rules have changed. For example, at one time, the costs were payable out of the estate and we're going to be payable on a party-and-party basis. Now we see that the costs of estate litigation are typically going to be paid by the party who's unsuccessful, and we may very well have full indemnity costs that are being ordered. So to my mind, I think that it's worthwhile considering the notice of objection as a pleading, as a document that allows for you to put your client's case in front of the court. And we're not doing orders giving direction today, and that's going to be the subject of future seminars. But we know that in the last number of years, the courts, when it comes to making orders at the first appearance, at the first stage of an order, or the first order of giving directions, are paying closer attention to the merits of the litigation and ensuring that extensive production or examination orders are not going to be ordered as of right. We're going to try to control how much time and money is being spent on these proceedings. So from my perspective, and people may feel differently, and there's a lot of very experienced litigators that are in the audience today, and I would welcome their comments or questions or criticisms on this point. But it seems to me, whenever you have the opportunity to put in a document to the court, whether it's a case conference brief or a factum, or in this case, the notice of objection, that's a great opportunity to put your client's case before a judge, as well as to outline for your opponents what it is that how you conceive of this case, and quite frankly, the degree to which the sincerity of the objector shines through. Like, is this really just something that's spurious, and you're trying to, you have a nuisance, a person that's seeking a nuisance settlement that's trying to interfere with the administration of the estate? Or actually, do you have a real will challenge here? And even at an early stage, the objector is going to set out some of the circumstances that give rise to the objection. And I've got to say that I strongly favor approaching the notice of objection as a pleading, because I think that it does signal to the other side seriousness, and it does provide an opportunity to put a document into the court file that you can reference both on the order giving directions or at a case conference moving forward. I mean, you don't have to, obviously. And as Brad has said, these things are often just pro forma, where you list the traditional grounds to argue that the will is invalid in some way. But I think it really, if you approach this as a document of record, as a document of persuasion, the same way we would do in a statement of claim, I think it does provide an opportunity to advocate on behalf of the objector. And so to my mind, that when you put in a pro forma notice, it's an opportunity lost. And I, from my perspective, I would urge people not to do so. So that's what I think, Brad. Now you can tell me why I'm wrong.
I'm not going to tell you that you're wrong, but I'm going to be devil's advocate.
Why should you be different, Brad?
That's true. Let me be devil's advocate and say, ultimately, we know that the notice of objection is really just the first step in a process. Inevitably, there's going to be a more fulsome document prepared that's going to be seeking substantive relief, like a will challenge application. And isn't the concern is twofold, I guess I would say, which is, one, when a client comes into the office, you don't really have a sense as to where the administration of the estate might be at, and they may not either. And obviously, and we're going to be coming to this later in the discussion, scenario changes when a certificate of appointment has already been issued by the court, and in terms of what a person seeking to challenge the will can do. And so I guess my question is, like all pleadings, they take longer. And is the ability to present an initial document before the court, I would say that the need for urgency, i.e. to get the document filed as soon as possible, would trump that issue, because we know what follows after is going to be much more substantive. And I'm curious to hear what you would have to say to that.
Okay, well, obviously circumstances matter. And to the extent that timeliness of filing the objection becomes important, or the ability to obtain the full story from the client becomes problematic, I can understand why one would want to default to a less burdensome approach. But again, I'm going to just fight my corner a little bit more and say that, to my mind, anytime I can put in a document to the court that is going to represent an advocacy opportunity, I'm going to take it, especially if it's in writing. And I'm going to reference it, and I'm going to put it in my materials, like at every opportunity. And so normally we don't see the notice of objection after it's been filed. It's kind of like, you wave your hands at it, and in the recitation of the litigation history of the matter, it's going to be noted that the notice of objection was filed at such and such a time, and the notice to the objector went out, and all the rest of it. And that's fine. But on the other hand, there's not too many documents that do go in at an early stage. On a motion for directions, maybe there is going to be an affidavit that sets out, some of the circumstances, but you're going to be somewhat careful about what you're putting in the affidavit material, because your client is going to be cross-examined on it, eventually. Some jurisdictions actually do require affidavit evidence on a caveat being filed, to use old speak in Ontario, or what's still contemporary in other jurisdictions. That's not always the case. I mean, in the United Kingdom, there's basically a self-rep kind of form that's available online, which they use. In other jurisdictions, particularly in the Atlantic provinces, for some reason, things are a little bit more old-fashioned, and sometimes affidavit evidence is required, even with the caveat that's going in. But I guess my point is that this is not even an affidavit that's going in. So you don't have to be too afraid of your client being cross-examined on it, or even it being held to the four corners of the document going forward as you would be in a statement of claim. So on the one hand, I do understand that this is, more work, and more work is more legal fees for the client, and we don't want to charge more money to our clients than we have to. But if it represents a leg up in any way, if it represents an opportunity to get a judge on my side or to understand the story in any way, I'm going to take that each and every time. And so, all things being equal, I'm going to pay attention to that notice of objection going in, and I'm going to use it as the opportunity to tell a story both to the court and to the other side. But that being said, I understand your point about timeliness and about cost, absolutely. And this is where a lawyer's best judgment has to come into play as to what is in the best interests of his or her client.
Great, thanks, David. We'll circle back to you shortly. I'm just going to continue on about another tactical consideration when it comes to filing a notice of objection, and that is where to do it. Obviously, it's common to file a notice of objection in the same courthouse in which the probate application was filed, but it is not per se necessary. The Estates Manual in Ontario indicates that court staff will use the estate system to search the provincial database of estate documents and arrange for the notice of objection to be sent to the applicant who filed for probate, regardless of what courthouse that notice of objection is filed in. So that comes in handy if, for example, the retained lawyers in Toronto, and it's easier to coordinate getting the notice filed here rather than having to make arrangements to have it sent up to, for example, Sault Ste. Marie to have it filed. But as sort of we alluded to a moment ago, timing can be an issue in certain cases. For example, in many cases, an application for a certificate of appointment may have already been filed with the court, but has not yet been issued by the court when you file your notice of objection. So as long as you get your notice of objection filed before the certificate of appointment is actually issued, you're okay. But what happens if, for example, you file your notice of objection in Toronto, but the certificate of appointment was filed in Sault Ste. Marie? And even if it takes 3 or 4 days for the court staff to get the document on the provincial database, in the interim, probate in Sault Ste. Marie could be granted. So timing is a tactical consideration about where you get the notice of objection filed. But let's assume for the moment that you do get the notice of objection filed. Now what? First, we'll talk a little bit about the technical requirements, but then we'll get more into a discussion about strategy analysis. So again, once you're on the technical side, once the notice gets filed, pursuant to Rule 75.03 of the Rules of Civil Procedure, the registrar must send the notice of objection to the applicant who files for probate. Upon the applicant's receipt of the notice of objection, the applicant must then serve another standard document, the notice to objector, on the objector and file a copy of the notice with the court. And then the rules say that within 20 days after receiving the notice to objector, the objector must serve and file a notice of appearance. Now, again, the notice of appearance is a standard pro forma document that comes about whenever there's an application that's being commenced. But in this case, it's actually crucial that the objector follow this procedure, because if the objector fails to file a notice of appearance after receipt of the notice to objector, the probate application by rule will proceed as if the notice of objection has not been filed, which in turn would permit the estate trustee to secure a certificate of appointment of estate trustee and commence the administration of the estate. So overlooking that timeline presents an early opportunity for the named executors, with the help of their lawyer, to potentially stop the notice of objection from stalling the probate application and requiring the estate to retain an estate litigator. And it also creates a significant liability issue for the objector's lawyer if they fail to meet this timeline. But let's again assume for the moment that this process is followed. The court sends the notice of objection to the estate trustee serves and files the notice to objector, and the objector serves their notice of appearance within 20 days. Now what? So the rules again provide that the applicant is then permitted to bring a motion for directions regarding the validity of the disputed will. And if the applicant fails to bring this motion within 30 days after being served with the notice of appearance, the objector may bring their own motion for directions. And I'm going to ask for David to come back for a moment and we'll to chat about this issue. From an estate trustee's perspective, do you think there's an advantage to bringing a motion for directions regarding the validity of a disputed will? Or is it preferable just to wait and see if the objector will actually bring their will challenge application?
From my perspective, anytime I'm given the opportunity to be an applicant or a respondent, I'd rather be an applicant. So the same way with the motion for directions. If I can be the moving party, I'm going to want to be the moving party each and every time. It allows me to control, the process a little bit more than being a respondent. And to my mind, on behalf of the estate trustee, it demonstrates or it provides for a demonstration for the court to show that here's a person that really does want to defend the will, administer the estate, and is going to do everything in a timely way. So, I know that, people have different views on this, tactically as to whether they want to force the other side to the task of preparing materials to bring the matter into court, bearing in mind the costs of doing so and all the rest of it. But to me, anytime, especially on behalf of a fiduciary like an estate trustee, that I can be the moving party or the applicant or have carriage of the proceeding, absolutely, I'm going to take it. And to my mind, that's actually is a very advantageous position to be in, rather than being a respondent.
So what if you're faced with, or not you, but the estate trustees, basically all they know is it is let's call it a pro forma notice of objection. So they don't really know what the scope of the allegations that are going to be raised in the will challenge application to come. Even in those circumstances, you would still be inclined to act as the applicant on behalf of the estate trustee, even though they don't really necessarily know exactly what it is they're going to be.
Absolutely. Part of the thinking going forward then is going to be to find a way to force the objector to be transparent about what it is that they're alleging. And so, I would want to couch things in terms of a statement of issues to be tried going forward on that in the initial order giving directions, and want to tie them down, rather than just leaving things really loose. And the objector is going to want to fish through the evidence and figure out, can they make out suspicious circumstances or not? But this is where the cost rules are, become important. You want to be able to pressure the objector to make their case as quickly as possible so you can meet it as quickly as possible and argue that you're trying to keep the costs of the litigation down and punish them in costs at the end if they don't advance their case, properly. So again, to my mind, it really just becomes a question of, tactical considerations. Am I better off having some degree of control? And I would say, yeah, all things being equal. And I understand that clients have limited budgets for litigation, and so hard decisions have to be made as to how to spend those resources, and that's fair enough. But all things being equal, I would say that I would prefer, again, to seize control of things and then put my opponent's feet to the fire to be able to state as early as possible what it is that they're objecting to, what circumstances that they require the evidence to make out, and then to use that to narrow the proceedings moving forward, because otherwise it's really hard to know what it is that you're responding to when you don't force the objector to plead what it is that they're objecting to.
Fair enough. So we talked now a bit about the process of when a notice of objection is filed, but now I'm going to cede the floor to David, who's going to talk about what options are available to a person seeking to challenge a will where the certificate of appointment has in fact been issued already to the estate trustee. So David, over to you.
Thanks very much, Brad. So Folks, this is where I want to reference the rules. And I've just marked 125 exams in civil procedure. And so I've got the rules on my mind more than I would normally do. But there's some interesting rules that are quite old that are within Rule 75. So Rule 74 and Rule 75, as you know, are our rules within the rules of civil procedure. Those are the old surrogate court rules, which have be retained in the rules of civil procedure. And Rule 74 5.04 and Rule 75.05 make available provisions, provide a jurisdiction to the court to revoke a certificate of appointment that's been made, and to order for the return of a certificate of appointment. 75.04 is an application, 75.05 is a motion. And so I'm not going to read the rules out, but I would like to sort of describe them just a little bit. 75.04 allows a person with a financial interest in the estate to apply for the certificate of appointment to be revoked. And so the rule provides 3 circumstances where that can happen. The certificate was issued in error or a result of fraud. The appointment's no longer effective, or any other reason. So the certificate was issued in error or as a result of fraud. Well, let's leave fraud for to the side for the moment. If it's an error, whose error are we talking about? Well, it may very well be just an error on the part of the parties that thought that the will was the last will, and we've now discovered actually there's a later will. And so nobody's at fault here, really. All we've got is probate that's issued over an earlier will, which is revoked by a later will. So obviously you're going to need to have that certificate brought back in, returned to the court, and a new certificate issued in respect of that new will. The other circumstance is the appointment's no longer effective. And that normally means the estate trustee has passed away. And if that's the case, we just need that certificate to be brought back in. Any other reason is often where the application is made together with an application for removal under the Trustee Act to remove the estate trustee for cause. The motion for the return of the certificate under Rule 75 is really the thing that dovetails with what we're talking about today. So this is where there's a motion that's being brought to ancillary to a determination as to whether the will is valid or not. It can also be that return of the certificate can be made with respect to that other rule, Rule 75.04. But normally, the motion that's being brought now is being made together with the notice of objection that's being filed. So obviously, if the certificate of appointment is already issued, 1, there's got to be a good reason to bring it back in, and 2, now there's going to be a question of time that becomes important. And this really is significant, because if we're going to allow probate to return, conceptually, we're going to have to think about, well, what about all those transactions that were entered into on the strength of the existing certificate of appointment itself? And we're going to have to deal with that at some point. But at the same time, is it now too late for a will challenge? And now this brings us back to a topic that we dealt with in the first seminar, and that is limitations. And we all know that there's no limitations period in respect of declaratory relief. So you can get a declaration that the will is invalid, but there is a limitation period in respect of consequential relief, and that becomes an issue just under the Limitations Act, as well as this is where the equitable defenses of laches and acquiescence come in. That is, did the objector wait too long and allow the propounder, the estate trustee, to really change their position and detrimental reliance on non-action on the part of the objector, Or was there implicit or explicit acquiescence in the certificate of appointment being issued earlier? And so this is where these are the kinds of considerations that the court has to deal with on a motion to return the certificate of appointment. There's not many cases on point. There are a couple of recent cases. There's a case called Birmingham Estate, which is a judgment of Mr. Justice Perel, a 2007 judgment. And there is another judgment decision called Prong Estate in 2011, which is a judgment of Justice Gordon. Between the two of them, the Birmingham Estate case is a little more detailed. Justice Perel considers law in greater detail, and there's a couple of points that come out of this case that I think are helpful in understanding the nature of the court's jurisdiction in ordering for the certificate of appointment to be revoked and or returned to the court. The first is that, as the court says, this is not just a perfunctory exercise. The court really does have to inquire into whether there is an arguable case on the merits. Because if, in fact, there isn't a well-founded challenge to the will, return of the certificate of appointment can be highly prejudicial to the beneficiaries of the estate, as well as to the estate trustee. And so I'm sorry about reading things out. I know nobody likes that, but I'm just going to read out two sentences from Justice Perel's judgment. This is after he had reviewed the historical cases with respect to the court's jurisdiction to have probate recalled, and specifically some 19th century jurisprudence that really spoke to very old considerations in the prerogative court in the United Kingdom. So he says, in reviewing the above cases about the doctrines of leches, acquiescence, and waiver in the context of a late arriving claim to have a will proved in solemn form, I note a judicial reluctance to employ these doctrines to preclude proof of the will in solemn form because it's sound policy to have the validity of the will scrutinized when there are suspicious circumstances or reasonable doubt about the testamentary capacity of the testator or the testatrix. What does that mean? Once again, we're dealing in estate litigation with the validity of wills. And what does that mean? That means that there's a document that is going to create in rem rights, that is rights in property. In rem rights in the estate assets being held during the course of administration by the estate trustee, and then a contingent right in those same assets on the strength of the will for the beneficiaries. And so if a will is to create in rem rights to allow assets to pass from the deceased to his or her beneficiaries, to say that we can't look at the validity of the will after probate is issued because it would just be inconvenient, that's highly problematic, because that waters down testamentary freedom, it waters down property rights, and it really waters down the whole point of the exercise, which is to ensure that the property is going to vest in those people that it should properly vest in. At the same time, there's got to be a balancing of interest. So Justice Perel says, when we look at leches, that is that equitable doctrine that says if you sit on your hands for too long and there's detrimental reliance, you can no longer sue, or waiver or acquiescence or any of those other equitable doctrines, we're going to look at those doctrines, but we're not going to read them at such a high level as to prevent a serious arguable case going forward that would allow the will to be challenged, even if it's just a matter of declaratory relief, even if consequential relief is not going to be available based on the Limitations Act. And so, in this case, there was an 8-year period of time that was at issue here. And what was interesting is that at the end of the day, Justice Perel said, I think what we should do is we should approach this the same way that we would approach setting aside default judgment. Not on exactly the same considerations, because obviously the context is a bit different, but what are the reasons that gave rise to the delay? And are those reasons, serious ones, or are they not serious ones? And we'll have a look at that and be able to balance these reasons for the delay together with these other important considerations with respect to the proof of the will. The later case that I mentioned to you, the Prong Estate case, this is a later case, so it's a few years later than the Birmingham Estates, 4 years later. In this, Justice Gordon confirms the soundness of Justice Perel's approach in the Birmingham Estate case, and looks really at the context of the litigation and really just says that the time period has not been adequately explained by the objector. It doesn't seem to be an arguable case to set the will or the granted probate aside, eventually, and refuses the motion to have the certificate brought back in. What do you get from all of this? Again, there are good reasons and maybe less controversial, less contentious reasons why probate has to be recalled. And the clearest example is, as I said, I think is where you just find a later made will that nobody was aware of. And, we're not talking about defects in the will. We're just talking about a will that's no longer effective by virtue of a later made will. In those cases, I think only the passage of time is going to be important to determine whether consequential relief is going to flow from that or not. In the harder cases, which is what we're talking about today, where there's a notice of objection that's being made with respect to the validity of the will, this is where the delay in commencing the litigation becomes important. And since Madam Justice Greer's decision in the Liebel case was made, we really are focusing on limitations and delay and prejudice in a little bit more of a pragmatic way than we have in the past, and in a way that I think really comports with our attitudes toward civil litigation generally, and the public interest in making sure that litigation proceeds in a reasonable way. And so when it comes to these return questions, and they do come up from time to time, I think that counsel really needs to focus in on the delay in bringing the objection forward and explaining that adequately on the motion. And because if that's not the case, just as was the case in the Prong Estate case, the relief is going to be refused. So that's rule 75.04 and 75.05, both of which will be on the exam. Over to you, Brad.
Thanks, David. Well, I think now is a good time to open up the floor to any questions anybody has. And I actually did see one question in the chat.
Oh, I see one too. Somebody asked for the citation for the Birmingham State case. If I can just give you that, I'm going to put it into the chat as well if I can. I have the Estates and Trust Report site rather than the Canley site, but you can probably punch it in and you'll get it the same way. It's 2007 32 ETR 3rd 292. And I'm going to try. Oh, I did it. I put it into the chat box.
Thanks. So above that is a question: in what circumstances can someone file a notice of objection to a in respect of an intestacy, so certificate of appointment without a will? One, obviously the notice of objection can be submitted because it's a similar form, certificate of appointment with or without a will. One example of a scenario where I've used it in the past would be often if there's a situation where other beneficiaries under the intestacy suspect that the person who's applying to be the estate trustee of the estate without a will also previously acted as an attorney for property and care for the individual, and they have concerns that that person may have taken gifts, received gifts, or taken money improperly during the time period prior to the deceased passing. That's a circumstance where I would put in a notice of objection to prevent them from getting named as the estate trustee, because essentially it puts them in an immediate conflict where you're going to want to have them pass their accounts with respect to their time as attorney for property. And in addition, you just don't want them to have immediate access to the deceased funds if you already have suspicions that previously they actually breached their fiduciary obligations to the deceased while he was alive or she was alive, and took funds or used funds improperly. David, do you have any other scenarios?
Yeah, I would just say that kind of just to add on to your comments, there's a really nice case, I think it's 2010, called Gonder and Gonder Estate and the Court of Appeal, and this is the leading case on the court's jurisdiction to pass over an applicant for probate, and the court normally, I mean, we normally have these same kinds of questions that arise as a removal when you want to remove somebody under the Trustee Act. Well, there's a narrower jurisdiction to pass over an applicant. And one of the reasons might be on the conflict of interest point that Brad raised, or there might be others. And so where the notice of objection becomes important, I think, where the application is made on the basis of the intestacy rules, is to center in on the applicant himself or herself, and that would be the objection, either that for whatever reason they're not the right person, and it might be really easy. Let's say that they're a foreign resident, that's going to complicate matters, or if there is a conflict of interest or something else. That's where the notice of objection, I think, can be useful, but it's a little bit of a harder ask when you're seeking to pass over the applicant. There really does have to be a very good reason.
All right. I see another question. In practice, have you ever used a request for notice of commencement of proceeding instead of a notice of objection when you have limited information about a estate or will? I have not.
I haven't because I think that the one thing with the notice of objection is it does make everything stop. And that is the utility of the notice of objection. Like, no estate registrar is going to be issuing a certificate while that objection is in the court file. And I don't think that you're going to have that automatic consequence that arises on any other basis. And you really don't want to have to go through a motion to have probate return, especially because the certificate might have been used to affect transactions. So I'm not sure I would think that's such a great idea myself.
I think Charles Wagner has a question for us as well. So Charles, if you want to join us and ask your question, please do so.
I'm wondering how your strategy might differ if the objector is a self-represented individual, because if they don't know the rules and they don't file a notice of appearance, you can push probate forward. I agree with David's comments earlier about being the applicant controlling the process, but I'm just wondering what you guys think. Would you adjust your strategy if it was a self-rep?
No,
I don't think I would either. And because obviously, let's back up. We're presuming that when the unrepresented party received the notice to objector, they actually did properly serve and file their notice of appearance. So at that point, that avenue of sort of being able to easily proceed with the administration of the estate is not going to be an option. And so then we're into a question of there's a right on of the estate to bring a motion for directions, or you can wait the 30 days and give the unrepresented party the opportunity to initiate the application. As long as the action or the application is out there and there's no immediate limitation period issue, I would still be inclined to push it, because one way or the other, you have to bring them before the court and to try and have the matter adjudicated. And so keeping the pressure on and forcing them to disclose the basis for their position, I still think makes strategic sense to try and take the initiative if it's available to you.
Hi, Brad. I just had a question, kind of expanding on what Charles was saying there, and it occurred to me: what if they fail to file a notice of appearance? There is that 20-day limitation, I guess, for them, that the probate application can move forward after 20 days if they haven't filed the notice of appearance. Is it your experience that the estates court will do that administratively, or do you have to take some active steps to force their hand on it? Do you have to move, or are they just going to step in when you make a motion and cure that default by filing the notice of appearance?
David, I don't know if I've
I would just write the estate's registrar and ask them administratively to issue the certificate. Patrick, I'm sorry but you're going to have to, can I just suggest you edit your screen name, because you got a client name stuck in there from probably a previous proceeding.
My apologies for that.
Yeah, I think the easiest course that I would suggest is always just to write to the estate's registrar and see if you can do it that way. And if not, then to ask that the matter be forwarded to the duty judge. Anything to avoid having to bring a formal motion.
Well, we're almost.
I have a question, Brad.
Okay.
Okay. Do creditors of an estate qualify within the meaning of the Rules and Estates Act to file a notice of objection?
So the answer to that is definitely maybe. There are mixed case law as to whether or not a creditor can actually get standing by way of a notice of objection. So the answer is it's not really definitive. There's a couple of cases. There's a Geffen case where it appears that was a case where the individual was an alternate estate trustee of the will, but it was also a creditor for costs related to a trial directly related to the estate. And in that circumstance, the court found that, yes, they did have standing. But there's another case, the Magnotta case, Magnotta v. Magnotta, which suggests that creditors are not permitted to file a notice of objection because Rule 75 is not intended to be used by creditors to secure recovery of assets within an estate. I think that the facts of that case were more, because of the specific facts of that case, I think the pronouncements of the judge were perhaps a little bit too broad in its application, because they were trying to justify in that specific case not giving them the ability to do it. So I'm not sure that that's correct, but it's out there, and therefore you have to factor that in as to whether or not a creditor in fact will be able to have standing to file a notice of objection. All right, well, it looks like, unless there are other questions. Oh, sorry, there's a question about yes, I'm happy to provide let me just put in there was a request for the citations to be put for those two cases I mentioned. I'll plug them in here if I can.
Hey, gentlemen, before we go, I would just ask that the two of you comment on one other matter, because I'd like to take the perspective of the objector. The objector files a notice of objection. And he's not safe because the authority comes from the will, and the executor can still take action with respect to certain assets. So I'm wondering if you can go through that and what strategy you would take for the objector if you were concerned, for example, that some of the assets are bearer bonds or some of the assets are private shares. What would you do if you represented the person objecting, if you had concerns like that?
Bring the matter to court for injunctive relief. I mean, I would certainly, if it was me, advise the objector that as a trust obligations will still be imposed on them, whether it's on the basis of the will or otherwise. If they're what they call a trustee de santort, if they're just a trustee by virtue of their own wrong, and if they use the will in the interim period between the notice of objection and the order giving directions to affect transactions, you know, they may have some issues. But if they're really, if you can't get an undertaking and there really is concern that the nominated estate trustee is going to affect transactions based on the disputed will, obviously it's right to third parties that are affected, like a bank. I mean, normally they're not going to do anything once they hear that there's a will challenge. They're going to freeze everything pending a court order. But if that's not enough, I think this is where you really do need to get an injunction as quickly as possible to prevent the assets of the estate being prejudiced. That's my view. Brad might see it differently.
No, I agree. I mean, obviously there's scenarios like the first dealings exception to that allow properties to be transferred without probate in certain circumstances. So if you have concerns regarding the conduct of a person who's purporting to be the estate trustee, that they're going to take action to essentially benefit themselves, even transfer the property to themselves, and then the only option is to get into court and get injunctive relief to prevent that kind of transfer from taking place.
How about you, Chuck? What do you think? What's your practice?
My practice is to get into court as soon as possible. And if there are, for people of means, often the private shares represent a great chunk of the wealth. And depending on who is on the other side, if they're a self-rep or a counsel who I have confidence in, I might be satisfied with an assurance from them in writing. But usually I would go straight to court. I wouldn't pass go. I wouldn't collect $200, and I would make sure my client's protected.
Thanks, Charles. Well, I think that we've come up to our time allotment. So thank you all for joining us today and for your time. Just to let you all know, our next seminar is scheduled for May 24th, and it is about the first court appearance and orders with respect to a will challenge. And that seminar will be led by Craig Vanderzee and Tanisha Tulloch. So I believe there is a link in the chat for the next seminar. And if you haven't already, please register to join with us again. And just another friendly reminder to get your certificate of attendance downloaded from the chat before you sign off. And on behalf of David and me, thank you all for joining us today, and we really appreciate it. Take care.